You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes. You know, the song says to put a little love in your heart, but sometimes that's a bit of a challenge if you're going through legal issues with someone that you might love or used to love. But with us tonight from the law firm of Reynolds, Horn, and Servant is Mr. Wendell Horn to help us sort out some love in the law questions. How you doing, Wendell?
Oh, just fine, Morgan. Glad to be here. Coming up on Valentine's Day, we have a great guest tonight. Ashley Brody is going to be with us remotely. She is an undergraduate, University of Georgia graduate, so she's a big bulldog by heart. Actually, she's tough as nails. She played rugby at the University of Georgia, and for anybody familiar with rugby, that is a tough sport. From there, she then went to law school at Georgia State. She practices law in Macon and in Gray with her husband, Sean. They do a lot of domestic work, criminal work, and personal injury work. So, Ashley, we're glad to have you here as a guest tonight.
Well, good to be here. Thank you, Wendell. Good to see you, and good to see you, Morgan.
It's good to see you as well, Ashley. Welcome back. Well, you know what? Love is in the air these days, but for some folks, it can be a painful situation. So since we're dealing with love and the law, let's get into some questions that have been sent to us because people really want some answers. Let's begin with Melanie's question. And her question goes a little something like this. What if there's a custody arrangement, but one parent takes social distancing very seriously and the other one encourages the kids to ignore it? Is this something that the first parent can put a stop to? Is that how it works? Is it as easy as that, Ashley?
Not really. One parent can't dictate the way another parent parents their child, or the way in which the other parent parents while the child is in their care and custody, especially some things such as social distancing. One of the executive orders issued by the governor very early on addressed visitation and custody arrangements because we were receiving numerous calls and emails with parents saying, you know, we're in quarantine, or, this shelter in place order is in effect, and I do not want to send my child for visitation. Or the non-custodial parent was calling and saying, I'm not getting my visitation. The custodial parent's denying my time because of the stay in shelter in place order. The executive order that the governor issued was very clear that none of the executive orders were intended in any way to alter or affect visitation and custodial arrangements. And so visitation is set to go forward like it's detailed in the court order. And the custodial parent, even if the other parent's perhaps not parenting the way they wish, as long as it's not medical negligence, must allow that visitation to move forward.
Okay. All right, Wendell?
Never thought
Any
we'd
thoughts?
be dealing with something like that in COVID-19 situations, but I guess the law is ever evolving.
That's right.
Indeed it is. And speaking of COVID-19 situations, what about trials? If you're in the middle of a divorce or you have a child custody hearing coming up, can you do it by Zoom these days? Is that how it's happening?
Well, really, actually, I know in the domestic field, y'all are having a lot more hearings via Zoom and also in person than we would in front of a jury. I mean, juries are problematic when you got to bring a bunch of people in, oftentimes 60 to 100 individuals that are going to be in relatively small rooms. It's very hard to social distance with a jury in place. But as far as hearings are concerned, we're doing a lot by Zoom. We are not doing that many live. What's your experience with that, Ashley?
Well, you're exactly right, Wendell. And I think it's one of the reasons why the Supreme Court still has in effect suspensions of jury trials. They tried for a brief period of time to begin having jury trials again safely, and it just poses so many problems that those have been suspended again. And so hopefully those will resume in the next couple of months. But in the domestic world, we are having a lot of hearings, some in person, and courts are very aware of socially distancing and practicing all the CDC recommended guidelines, and then a lot via Zoom as well. So it's keeping the calendars moving, which is a good thing, because there for several months, I know people could not get into court and were having, difficult times dealing with these difficult problems and not having a judge to be able to tell them what needed to be done. So thankful to be back in court.
That's right.
And keeping
Morgan,
everybody safe.
Oftentimes, particularly on the personal injury cases, there's a lot of discovery that's done preliminarily before a case ever gets to trial. That has continued. We're still answering written interrogatory discovery questions, doing depositions, live and by Zoom, primarily by Zoom, a lot of mediation. So those cases are still moving forward. But
well, that's good.
Ultimately, you can't get in front of a jury.
Right.
Okay. All right. But at least it's moving forward, and that's a good thing. Let's move on to Michelle's question. And she has a question that goes a little something like this. My ex lost his job and has had to move in with 2 friends. Now, that means that when he has custody of the kids, he's now sleeping at someone else's house. Can I refuse to go along with this arrangement? I don't even know these people. That seems like a fair question, Ashley. The concern for your children, but is it legal? Is it right?
Certainly. And I understand from a mom's point of view, wanting to know where your children are, where they're laying their head at night, and who's around them. However, a custodial parent cannot, again, dictate the parenting time of the non-custodial parent. They can't just say, well, I'm not happy about this, so you're not getting your visitation. If she feels that the children do not have proper sleeping arrangements, if they're being forced to sleep on the couch or sleep on the floor or something of that nature, or if she has information that someone in the home, some of these friends that he's now living with, have criminal records or drug histories, things of that nature that escalate the situation, the danger of the situation that the children may be in, that their welfare and well-being's not being cared for in the environment that the non-custodial parent has them in during visitation, then mom can certainly file a modification to change that visitation schedule until the father can find more appropriate living arrangements while he has the children.
Okay. All right. Ms. Ashley Brody, who's a family law attorney, and Wendell Horn, who's a personal injury attorney, are with us tonight, and we're answering your question about love and the law. I'm Morgan Dukes, and I'll be back with more of Law Call next.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and our attorneys tonight are Ms. Ashley Brody and Mr. Wendell Horn, both of them great attorneys, and we're talking about love and the law. Now, it's wonderful to be in love, but when you're not so much in love anymore and you find yourself in a legal battle, that can be quite uncomfortable. But we have 2 great experts here to answer any legal questions that you may have had. In fact, we have a few that have come into us, one from Kevin. Kevin wants to know this. He says, my ex has primary custody of our 2 children, and she's talking about moving to live with her mother, who's in another state, which will greatly affect my visitation options. Do I have a say in this? Miss Ashley, what happens if one parent moves to another state?
Absolutely, he has a say. The custodial parent cannot make decisions that negate or interfere with the non-custodial parent's visitation rights. And a custodial parent, or both parents, are required to inform the other if they intend to move, keep the other informed of any address changes. And so as soon as he's aware that, yes, she is relocating and it's going to affect his rights, he can file a modification action to either seek primary physical custody to keep the children here with him, or to modify his visitation so that perhaps he has longer, more weeks in the summer, or most of the summer, most of the children's holidays from school, things of that nature, to compensate for the fact that he probably will not be able to have a routine visitation schedule with her living out of state.
Actually, sometimes we hear that come up with people calling in, even though we don't do that. But oftentimes the custodial parent has already moved and is in another state, and they're kind of doing this after the fact. I guess venue would still remain in Georgia, and how long do they have to file a modification?
If the initial order is a Georgia order and one parent remains in Georgia, then a modification would still be filed in Georgia, yes.
Okay.
Okay. Well, Wendell, I have a question for you. What happens if two people are in the middle of a divorce and one of them just happens to get into an accident and needs your services of a personal injury attorney? What happens if it goes bad in that direction?
Both parties have a right of action. The injured party has a right of action for the injuries done to them. The spouse of that party would have a loss of consortium right, which is a loss of services, companionship, that sort of thing. So they each have their own separate suits, but oftentimes they are dealt with in the divorce because one of the parents or one of the injured parties may have loss of income, lots of medical bills and that sort of thing. And actually, I guess y'all handle that when you're doing a divorce.
Okay. Well,
I assume, is that correct? Actually, I was
Yeah, that's right, Wendell, because like you mentioned, loss of income, that's a marital asset. That sort of goes back into the pot of marital assets that we're dealing with, an equitable division of, and who should get what. And so, pain and suffering would not be divisible, but several of the forms in which a person is compensated after an accident would be deemed marital and dealt with in the divorce action.
And Morgan, that's an excellent question because we do see that fairly often.
Okay. Well, speaking of assets, our next question comes from Stacy, and Stacy wants to know, she says, I've been a stay-at-home mom for 12 years now, and now my husband wants a divorce, and I'm not sure what job I can get that can pay all my bills. How do they decide how much child support would be? How was that done, Ashley?
So beginning in 2007, the law in Georgia changed to where we now determine child support by what is called a child support worksheet. And it is sort of an Excel calculator worksheet that takes into account the mother's income, which in this scenario, she does not have a current income, but what her income would be, or minimum wage. Takes into account the father's income and a few allocations that we call deviations, such as health insurance expenses, if there's private school expenses, if there's childcare, that's always a huge one. And then that determines what the non-custodial parent's child support obligation would be. In her particular case, she may also be entitled to alimony if she's been a stay-at-home mother for 12 years, even if she would request temporary. She could possibly request a permanent, they've not been married that long, but some sort of temporary alimony if her husband makes a good living, to allow her to sort of get back on her feet, get any education, any training she may need to join the workforce.
Okay. And alimony is very real here in Georgia, right?
It is. Now, it's not awarded it's not as common as people sort of tend to believe. One party has to show that they have the need for alimony and the other party has an ability to pay. So there's a significant difference in income. The requesting party in Georgia could not be found guilty of adultery. If they are committing adultery and that's the grounds for why the divorce is filed, then they are barred from requesting alimony. So there's certainly a lot of moving parts that go into account when looking at a request for alimony. But it's something in her particular case I would certainly look at that may help her, like I said, rejoin the workforce.
Okay. Now let's talk about social media. That's a hot topic these days because just about everybody has some type of social media account. And Alexa has a question in reference to that. Her question is, can I use pictures of my ex on Facebook as evidence in a child custody case?
I would ask what kind of pictures?
Yeah, you mentioned adultery earlier. I don't know if that's a factor, or maybe where you're taking my child. That might be a factor.
That's right. I would, the answer to that question is absolutely yes. Facebook, social media, text messaging, those things are some of my very best friends in a court of law because, a picture says a 1,000 words. I use Facebook, social media posts all the time as evidence against the opposing party in court to confirm or to support my client's sort of side of the case. And so absolutely, if he's got what I would call incriminating Facebook posts where, he's heavily drinking or he's out partying or he has the child places that are inappropriate or his girlfriend around the child, things of that nature, we absolutely would use and can use those Facebook posts.
Actually, I have a quick question. How hard is it in a divorce action to get the other party's text messages from their own phone?
It can be very difficult. It's easily obtained the numbers, that this number texts that number, but the actual content is very difficult to obtain.
Okay. Ashley Brody and Wendell Horn are our attorneys tonight. And when we continue, we'll be back to answer more questions right here on Law Call. If you have questions for family law attorney, Miss Ashley Brody, feel free to contact her at Brody Law Group, 544 Mulberry Street, Suite 101, right here in Macon. Her phone number is 478-936-9842. And you can also find her on the web at www.brodylawgroup.com. Now, if you have questions for Wendell Horn, you can find him at Reynolds, Horn & Savant, also here in Macon, at 478-405-0300. On the web, you can find him at www.reynoldsinjurylaw.com. And please don't forget to follow Reynolds, Horn & Savant on Facebook. Now we're back with these two great attorneys talking about love and the law tonight. And our next question deals with property division as well as child custody. It comes from Richmond, and Richmond wants to know, can parties settle property division and child custody issues out of court, or does a judge have to decide on these things, Ashley?
So absolutely, parties can settle their own issues, their own matters. A lot of times judges, when you get into court, will look at the parties and say, do you want a complete stranger determining the outcome of your lives, or do you want to talk about this and see if you can work it out? That would be an uncontested divorce case. Now, you would still have settlement documents drafted and the parties would sign those documents and they would be filed with the court and a judge would sign an order, but they can resolve all issues so that a judge is not determining the outcome of the case. Yes.
Ashley, wouldn't you still recommend that, particularly if there are many assets involved, that they go to an attorney to draw those documents? I mean, there are things that need to be included, and it just becomes a nightmare down the road if certain things are left out.
That's correct. And there's certain things that cannot be modified later, such as property division. So if that's not done correctly in the settlement documents, and an uncontested divorce is very affordable, but for the protections that it allots the parties, if they have minor children involved or property assets, things of that nature that are being divided, it's really invaluable to make sure the documents are done correctly.
Okay, that's important. Man, to make sure we have the right people involved for certain. Chris has a question that a lot of people have wondered about. Ooh, this is a financial question. And Chris wants to know, in a divorce, would a spouse be on the hook for the other spouse's debt? Now, I'm sure, Ashley, that has come to you more times than you can shake a stick at, huh?
Absolutely. So Georgia is what we call an equitable division state, which means a judge would look at anything that's been acquired, accrued during the marriage, including debts, and determine what is a fair and reasonable or fair and just division of those assets and debts. Quite often, although it is not the law, quite often the courts will divide those things sort of 50-50 if they incurred the debt during the marriage, or if they obtained asset during the marriage, sort of split it in half. Usually that's just what seems to be fair. But again, because that's not the law, because it's equitable division, the parties can argue to the court why that is not fair, because one party has gambled away all of this money or has incurred all of this debt, but due to a shopping habit or things of that nature, that it's not fair to divide things down the middle, and there should be a different division of those assets or debts. But absolutely, if it's incurred during the marriage, it's going to be dealt with in the divorce.
But it does not affect their rights to, in other words, if they owe a bank, they still owe that bank, even though the spouse may owe part of it.
That's right. I mean, a court's not going to tell a bank who they can and cannot collect from, but we have provisions in the documents. You know, if one party's retaining the marital residence, for example, we're going to have a provision that party needs to refinance to remove the other party's name from that indebtedness within a certain period of time, and that they're to hold the other party harmless for that debt. So if they fail to pay on that, the other party can sue them over their non-payment.
Wow. Okay. Well, speaking of splitting things up, our last question comes from Wynn, and he wants to know, if you inherit property from your family during the marriage, does the other spouse get half of that inherited property in the divorce?
Typically, no. And I would say, again, Georgia's an equitable division, so it's not an automatic half of anything. It is a fair and reasonable, fair and just division. But inherited property is different in that remains the sole property of the spouse who inherited that, so long as they do not commingle that asset. So they cannot have, if they inherited money, don't put in a joint account. If they inherit property, don't put the other spouse's name on the property. It has to be maintained separately and in the party's name that inherited that, to be a separate asset and maintained outside of the divorce, and then it's not subject to division in the divorce action.
All right. Family law attorney Ashley Brody has been with us tonight to share some great knowledge. Thank you so much. Wendell Horn, always good to see you. Always good to have your insight with us. And I'm Morgan Dukes, and I just want to encourage you to keep on watching. But until next time, this has been LawCall. Good night, everybody.
Good night.
Good night.